threatened me several times, and you keep allowing this man to walk. My son is a part of me. He has no custody in the state of Georgia at all. At all. DFAC emailed y'all and told y'all they did not give him custody of that child. They've been looking for him, and he has not complied in giving an address to where the child even is. Nobody is following the law. And you are the judge that sets the law. I'm a victim, and you are allowing my abuser to keep my child and continue to abuse me emotionally and mentally. It's unfair and it's injustice.
As a criminal trespass, the parties are ready to go forward. Previously, the state had announced that it was going to withdraw the motion, but after a conversation with all parties, the state has decided to proceed. The court has taken judicial notice of May 13, 2022. Magistrate Court Judge Charity Bridgewater issued an order for bond in the case, ordering that Mr. Boston have no contact with the named alleged victim, in this case, Cassie Benz, and also that he not commit any additional offenses. So at this time, the state is ready to go forward. They've called Officer Brandon Green.
Yes.
Officer Green, you've been sworn and you're ready to go forward with testimony at this time. All righty, go ahead, sir.
Thank you, Your Honor. And were you employed with the Clinton County Police Department on November the 29th of 2020?
Yes, ma'am.
Thank you. And are you post-certified and credentialed?
I am.
And are all of your credentials up to date?
Yes, ma'am.
And were you post-certified and credentialed on that date?
Yes, ma'am.
And do you have arrest powers?
Yes, ma'am.
And do you have powers to obtain warrants?
Yes, ma'am.
And did you have the power to obtain a warrant on that day?
Yes, ma'am.
And were you working in your official capacity on that day as well?
Yes, ma'am, I was.
Okay. And were you dispatched to 335 Upper Riverdale Road, Southeast Georgia, 30236?
Yes, I was.
And what was the nature of that call?
I responded to that location at the Chuck E. Cheese establishment in reference to a domestic disturbance.
Do you know what was specifically said regarding the domestic disturbance?
Yes, Miss Benz was having a birthday party for her and Mr. Anthony's child that they share together. I made contact with her. She advised that they got into a argument about Mr. Anthony bringing his girlfriend to the party against her wishes, so they stepped outside, to where she then stated that he started becoming irritated and irate and knocked the birthday cake out her hand, and then proceeded to shove her on the ground where she scraped her elbows before he hopped in the car and drove off.
Okay. And do you see the defendant in this case today?
Yes, ma'am. I believe that's him.
And can you just identify what article of clothing he's wearing?
If I can get the screen to large up. That's the gentleman standing in the courtroom right there behind his attorney.
Okay. And what color is he wearing?
I'll make this screen bigger. It's a collar shirt. It's hard for me to make out the color. It's a light colored collar shirt.
Okay. Your Honor, the record reflects that Officer Green has identified defendant for this motion to revoke bond hearing.
Record shall reflect that.
Thank you. During your investigation, you say you spoke with Ms. Cassie Benz. Is she the victim in this case?
Yes, ma'am.
Okay. When you spoke with her, describe her demeanor. How was her demeanor when you spoke with her on that day?
She was upset. She appeared to be in like an emotional distress state.
Mm-hmm.
And, she had the bruises and marks on her elbow.
Okay. Did she indicate to you how she received those bruises and marks on her elbow?
Yes, she advised that she received them from Mr. Anthony when they had stepped outside to where things went from a verbal argument to a physical altercation where he had shoved her on the ground.
And when you arrived on the scene, was the defendant there?
No, he had already left the scene.
Okay. Were there any other witnesses to the scene that you spoke with on that day?
No, there was no witnesses once because they had stepped outside away from the party.
Okay. And how did you conclude your investigation?
By determining Mr. Anthony as the primary aggressor, and then I went on to obtain warrants for family violence battery.
Did you obtain any other warrants on that day?
Just the one for the battery.
Okay. Any other warrants besides that one on that day that you obtained for the defendant?
No, I only took out the battery warrant.
Okay. And why did you obtain the warrant for the battery, family violence?
Because of the physical altercation where physical contact was made and she had received the visible injuries on her elbows.
Okay. And at some point, was the defendant arrested on your warrants? On your warrant? I'm sorry.
Yes, ma'am, I believe at one point he was arrested on the warrant.
Okay. Okay. No further questions for Officer Green.
Thank you. May I proceed?
Yes.
Officer Green, could you just tell the court the date that you responded to the Chuck E. Cheese?
November 29th of 2020.
Okay. And so you responded and you spoke to Miss Benz, is that correct?
Correct.
And you learned that there was a party going on for her son that she had with my client, Mr. Boston, is that correct?
Correct.
And so you had knowledge that there was at least several people in attendance at that party, correct?
Correct.
And you could have gone into the party and talked to additional witnesses to verify Ms. Benz's claims, is that correct?
There was no witnesses outside to witness the incident.
You didn't speak to anybody at the party. Well, let me ask you this. Did you ask anyone at the party who was there first, my client, Mr. Boston, or Mr. Benz? Did you verify that?
Did I verify what now?
Did you verify who arrived to the party first, my client or Ms. Benz?
I believe she was there first.
And that's just based on what she told you, isn't that correct?
Correct.
You could have verified that by talking to any witness at the party, isn't that correct?
If they wish to talk to me.
In the course, when you're investigating a incident, you have the opportunity to speak to people who are present, and you did not do that in this case, correct?
Yeah, we can't force people to talk to us.
I understand. Ms. Benz told you that the altercation started when she saw Mr. Boston's new girlfriend. Is that correct?
You asked the what now?
Ms. Benz told you that she was upset because of Mr. Boston's girlfriend being present at the party. Isn't that correct?
Yeah, that's what the verbal argument started at.
Did you speak to the girlfriend?
They were gone.
Okay. You verified the girlfriend was gone?
No, she wasn't involved in the crime
How do you know?
because she advised me that it was Mr. Anthony that assaulted her.
So again, Ms.
It's them two out there.
So essentially, all the information you have about what happened comes from Ms. Benz. Isn't that correct?
Hello? Hey, were you able to make contact? I turned it off. I don't know what happened.
Ms. King,
Were
please.
you able to make contact with the victim?
Hello, whoever's talking, mute, please. Everybody mute unless I'm talking to you or you're involved in this hearing. Thank you. All right, go back to Officer Green. I'm sorry, Mr. Lynch, repeat your question.
I don't believe I have any further questions.
Everyone on the.
Oh my goodness. If I have to say it one more time, I'm gonna remove you from the hearing and you won't be able to get back in. So if you are not the person I am speaking to or involved in this hearing, mute your device. Keep it muted. All right, continue.
Judge, I do not have any further questions for this officer.
All right, any redirect?
Not for Officer Green, Your Honor.
All right, does the state have additional witnesses to present?
Your Honor, at this time, I'd like to call Ms. Cassie Benz, please.
All right, Ms. Benz, remember you are testifying in a court of law. Please answer the questions asked, okay?
Ms. Benz, if you can please unmute yourself and turn your camera on. Thank you.
All right, Ms. Benz, sit down. Are you sitting?
I am.
Okay, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. So you're before the court as a witness for the state in this matter. Ms. Hagler has some questions for you. Mr. Lynch will also have some questions for you. And Ms. Hagler, your witness.
Thank you, Your Honor. Ms. Benz, I would like to draw your attention to November 29th of 2020. Do you remember that day?
Yes, it's my son's birthday.
Okay. And please tell the court what happened on that day.
On that day, I had a party for my son at Chuck E. Cheese. Mr. Boston brought the girlfriend to the party who we already had a conversation on not having her around my son because of the dynamic of the situation. The girlfriend was presented as the best friend and they were sleeping around with each other. And then once we separated and the altercation happened, she presented herself as the girlfriend. And it was taunting. It was a taunting situation where they were nitpicking at me, like, hi, I'm here, hi, regardless of what you say. So when we were at the Chuck E. Cheese, I came in with the cake. We were running a little behind, and I came in with the cake, and we were setting the table up, and Mr. Boston's girlfriend had my son in her hands playing basketball.
Okay. And how old was your son turning that day?
2.
Okay. And then what happened next? You said that the defendant's girlfriend had your son in his hands. What happened after that?
I asked Mr. Boston, could we step outside to speak? Everybody left out. We grabbed the cake. Everybody left out the door, and there were no other people there. It was just me and my kids, and Mr. Boston and his girlfriend and her children. And as we were outside speaking, Mr. Boston got upset because of the things that I was saying. And he told me not to step towards him and his girlfriend. The girlfriend started arguing with me. And as I was talking, Mr. Boston knocked the cake out my hand and he shoved me on the ground. And they got in the car, he grabbed my son and they left.
And so when the defendant shoved you to the ground, did you sustain any injuries?
Yes, I scraped my elbows, both of my elbows on the ground.
Okay. And what did you do next?
I called the police.
Okay. And then after you called the police, what did you do next after that?
The manager from Chuck E. Cheese came outside and she was like, I saw the whole situation. She's like, I actually called the police as well.
Objection.
So sustained.
Thank you, Judge. When at some point the police arrived.
Mm-hmm.
Okay.
Yes,
And
you have to say yes or no, Ms. Benz, because
yes, when the police arrived on the scene.
Okay. And did you explain to the police officer what happened?
Yes, I explained to the police officers what happened. My daughters also explained to the police officers what took place in front of them. They were crying hysterically. This is not the first incident of him putting his hands on me in front of my kids. A person can say what they want out their mouth. You can't get upset and put your hands on a person because of their words.
And prior to this incident, was there another incident between you and the defendant?
Yes, I had a home in Riverdale. I had a townhome. Mr. Boston was living with me. in my home and my 4 children.
I'm gonna object
And-
to relevance.
Well, Your Honor, this is relevant as it goes to the motion to revoke bond and the fact that the defendant did violate the order.
She referring to the criminal trespass case?
Yes, which happened before this case.
Okay.
All right, go ahead.
Me and my children were home watching TV. Me and Mr. Boston had we were in a disagreement, and I asked him to leave to move out of my home. Mr. Boston came to my home about, I don't know what time it was. It was late. I got a knock on the door. He was banging on my door. He was drunk. I said, "No, you're not coming in tonight. You need to come back when you're sober." Mr. Boston got upset because I wouldn't allow him in my home. He bust out my windows in my living room, came through my window, and jumped on me.
I'm going to object again, Judge. She's not referring to the criminal trespass case. She's referring to another case that happened previously. The bond condition.
That's what he got the criminal trespassing charge for, because he came to my property and he did not live there, and he busted out my windows and attacked me.
All right, so
Separate case, Judge.
I'm
Go ahead.
sorry.
She's referring to a completely separate case that Mr. Boston pled nolo contendere to, which is not the case that we're here about today.
Oh, you talking about the case in
Miss Vance, let the attorneys work this part out, okay?
I'm not understanding what he's saying.
Well, you don't need to, because this is something I need to decide between the attorneys.
She is
I
not.
need you to be
referencing-
quiet right now,
Judge,
okay? Mr. Lynch, what's going on now?
Ms. Benz is not referencing the criminal trespass case. As you heard her talking about Mr. Boston jumping on her, that is not alleged in the criminal trespass case that we're here about. She's referring to a prior case that has been disposed, and bond is not relevant to that prior case.
Yes, it is.
That case has
Ms.
been.
Benz, stop. Certain things that we're discussing are legal matters. There are matters of law, not what your opinion is. I gotta decide those. Now, you have made several statements that I've let you get away with, but I'm done. You have alleged that the DFACS has sent me a letter or called me. I have had no contact with DFACS. And let me just tell you, only time I have anything having to do with children is if a crime has been committed against a child that is a misdemeanor offense. DFACS has not contacted me in this case. I have no knowledge of any relationship or the fact that your child may or may not be with Mr. Boston. I have no knowledge of that. I am not the judge who would receive that information. So when you keep saying that DFACS has told you, DFACS has told me nothing. They've never contacted me. They've never sent me anything. I've never communicated with them. So when I tell you that there are legal matters that you may not understand pertaining to this case, and I'm trying to parse it out and explain as we go, but what I'm telling you is you have an idea about what's going on and how we've wronged you. And I'm telling you, I have no clue about what you're talking about, because I'm not the judge that would even get that contact. Okay. It's not part of this case. Particular things that go on with the status of a child, visitation with a child, custody of a child, all of those belong to the Superior Court, which is on the 4th floor. They have exclusive jurisdiction over certain matters, which means only a Superior Court judge can deal with them, or a magistrate court judge can deal with them if an offense is brought before the magistrate prior to being transferred to Superior Court. That's it. I'm in the middle. So that stuff that you keep telling about, I'm keeping you from your child, or I'm not doing enough, I don't have the ability to do that. That's Superior Court or Magistrate Court. Okay? So when you start talking about what is or isn't happening for the purposes of what I have to decide today, let the attorneys present the information. Let me decide any arguments that may have. And when you're ready to speak again, I'll let you know. Okay? All right. Now, Mr. Lynch, you're saying that this is a different issue than the one where a bond was issued. So if we're talking about a closed case.
She's referencing a closed case. The state alleged in 2022 CR 01949, the case at which the state is trying to revoke the bond for, that my client committed the offense of criminal trespass. There is no reference to any physical contact. There is an allegation that 2 holes were placed in a door at Mr. Boston's residence, not at Miss Benz's residence. She's referring to a totally separate case. And whether or not that's relevant, I just want the court to be clear what.
Okay, what was the date of the case that Ms. Benz is referring to, Ms. Hagler?
That was gonna be my question. Ms. Benz, what case are you referring to when you said that he jumped on you? Because I'm not referring to that case. I'm referring to another case. But what was the date?
I'm sorry, so many people keep calling my phone. This was in 2019, and the home we shared was not Mr. Boston's home. That was our home where all our children lived.
Okay.
And Mr. Boston attacked me in that home as well and destroyed my prayer room.
Okay, so Ms. Benz, so now, Mr. Lynch, what you're saying is that was a case that has since been resolved by a NOLO plea?
Correct. And as far as the 2019 case, I would ask Your Honor not to take that into consideration. First of all, I don't believe that a NOLO plea is supposed to be used in this manner, but either way, it's not relevant to the bond because that case has been closed. He has entered a plea. It's disposed of. Now, what she just referenced, I believe she was starting to allude to the case that bond was issued and that the state is trying to revoke his bond on the criminal trespass case, which allegedly occurred in May of 2020.
All right, so Ms. Benz, can we direct you to the case that you said, Ms. Hagler, it happened at Mr. Boston's home?
No, I did not say that, but you're right, Judge. I do want to direct.
Please direct her to the particular offense that you're talking about. So yes, Ms. Benz, listen very carefully to what she's asking you, because in order for either side to make their case, we have to be very specific about what events we're talking about. Okay, so when she's directing you, listen, don't just say everything that's ever happened, because I'm sure you and Mr. Boston have quite a long history, but there's some specific things that the court has to hear. And so it's better if you listen and answer the question that she asked you specifically, okay?
Yes, ma'am.
All right, thank you. All right, Ms. Hagler.
Yes, ma'am. And so, Ms. Benz, I do want to pick up with, you mentioned the prayer room. Talk about that incident that occurred on May 7th of 2020.
Yes, Mr. Boston had been drinking that day. He was really intoxicated. And what we were arguing about, I cannot recall. I was walking up the stairs and I had said something to him that he didn't like. And when I said that, Mr. Boston struck me in the hallway. We started fighting in the hallway. And after we were fighting in the hallway, Mr. Boston proceeded to go downstairs into our den area, into a room that I turned into my prayer room, where I have my prayer area where I pray, and I have certain things in that room. And he went down there and destroyed the room. He flipped over all the bookcases that I had, all my ancestors' pictures. He broke them. He broke the vessels that I received, the way I practice my religion. He broke everything in that room. He destroyed it. When the police got there, he had left.
Was there anything else destroyed in your in the home on that day?
Yes, he put 2 holes in the wall from us physically fighting.
Okay. At some point, did you call the police on that incident?
Yes, I called the police.
Okay. 1 second, Your Honor. And did you record or annotate any of the damages in that incident on that day?
Yes, I have pictures of the damages.
And can you please specify what the pictures are of?
Yes, the pictures of the holes in the wall in the prayer room. The damages to the prayer room.
Thanks, Your Honor, for the question at this time for Ms. Benz.
Cross-examination, Mr. Lynch.
Yes, Judge. So you mentioned, Ms. Benz, you and Mr. Boston's children that you have together. Isn't it true that you only have one child together?
Yes, we have one biological child together, but me and Mr. Boston was together since 2015.
Okay. And the address where this criminal trespass that you just mentioned, that was 8260 Holly Drive in Jonesboro, correct?
Yes, that's on my ID. Mm-hmm.
Okay. And how much was the rent at that location?
Our rent was
Objection relevance.
She claimed that she lived at the location.
I'm a resident at that home, and it's a valid. As long as I receive mail there, I'm a resident of that home. I don't have to pay a bill there as long as I receive mail there, sir. That's
Okay. So just to clarify, Mr. Boston paid all the rent and allowed you and your 3 children to live there for free.
no, he did not pay all the rent. Me and Mr. Boston went in on bills together.
Okay. So on the incident where he allegedly put holes in the wall, you said that he jumped on you in that incident?
Yes, sir.
You wrote a sworn statement in that incident in the police report, isn't that correct?
Yes, sir.
And in that sworn statement, you didn't make any mention of him making any physical contact with you whatsoever, isn't that correct?
Can you read the sworn statement, sir?
I sure can. At the date top, it says May 7th, 2020, time 7:42, name Cassie Bria Dene Benz. Starting from the beginning, Anthony Boston Jr. and I got into a verbal disagreement about the children coloring all over the walls while I was in the bathroom doing my hair. The argument led to Anthony Boston Jr. snapping, punching the walls, and destroying my prayer room. He crushed my spiritual tool, which is called an egun pot, as well as my altar I built for my ancestors, being very violent in front of my kids. I called 911 and he fled the scene. Why is there no mention of physical contact?
Because when Mr. Boston came up the hallway, I was in the restroom doing my hair. He got upset because our son that we shared together, and at the time, my 3-year-old daughter, they were coloring and they colored on the wall. So he got upset and started snapping and talking to the kids crazy. And I told him not to speak to the children like that. And when I said what I said to him, he got upset and he mushed me into the wall. That's how the door hit the wall and put the hole in the door, in the wall.
Why didn't you include that in your statement?
I did. And that's, if you have the officer, they had it recorded. You can pull the recording up, the video from the officer's camera.
Yeah, you are aware that the officer does have a body cam recording, right?
Mm-hmm.
Okay.
No, you have to say yes or no, Ms. Benz.
I am aware.
Now, I want to move on to the 2020, November 29th, 2020 allegation that you mentioned that happened at the Chuck E. Cheese. Isn't it true that you found out that this party was going on while the party was already going on? And
No, sir.
Boston was already there. Isn't that true?
That is not true.
You said you arrived late to the party in your earlier testimony.
I set up the party and asked him to bring my child, to drop my child off at his party. He brought the girlfriend and her 3 children who were not allowed to be around me because she kept telling him my child was autistic and my son is not autistic. She don't even want my son at his house, at her house. My son can't even go to her house when he's there.
Ms. Benz, you're not answering the questions he's asking you.
I'm just he's trying.
Not just saying. I need to know specifically.
I set the party. I set the party up.
Okay. Did you pay for the party?
I paid for my children to play. I put money on their cards for them to play at the Chuck E. Cheese.
Okay. Who called and said, "Hey, can I reserve a party room?" Is that the way it works at Chuck E. Cheese, or do you just go?
You could just go, and if they have a table available, you can, grab the table, order the pizza, set a little table up if you want to, or you can do a birthday party package where they set a big table and an area up for you. Unfortunately, at that time, I could not afford that.
Okay, so you all just were gonna go there and celebrate once you got there.
Yes, ma'am.
Okay. All right, go ahead, Mr. Lynch.
So, Ms. Benz, when you arrived, Mr. Boston was already present at the Chuck E. Cheese, isn't that correct?
Yes, Mr. Boston was there.
Mr. Boston was there. And you knew that he was there, correct?
No,
You said you were upset because he was there with the girlfriend that you didn't know. So you,
no, we know her, but we knew her as the best friend.
Mhm.
They were sleeping together behind my back in my home.
so it's your testimony today that you didn't know that Mr. Boston was at the party at the Chuck E. Cheese's?
I didn't know the girlfriend or him was there when I arrived. No.
You didn't,
You knew he was coming
Yes.
and he was expected to bring your child.
The child was expected to be dropped off. Not
Okay.
him, not the girlfriend, just the child.
Okay, but when he came, when was the first time you knew that he was there and that the girlfriend were there?
When I came in, I set my table up, and when I turned, Mr. Boston and the girlfriend was already in the corner with my son.
Okay.
But my son was supposed to be dropped off to me.
Okay, so when you said he was supposed to be dropped off to you, were you supposed to get there? Mr. Boston was gonna call you and then bring your son to you?
Yes, so when I got there, someone was supposed to bring Amir to the location, to the
And when
party.
you say someone, who was that?
Either his mom, his sister, because we weren't supposed to be in contact with each other.
Okay, so did his mom come to the party?
Nobody came. No.
So it was just Mr. Boston and the girlfriend
Yes.
and her children.
Yes.
And at the time you said y'all weren't supposed to be in contact. Were you aware that there was a no contact provision?
I was not aware of the no contact provision. I was just aware that from the previous situation that, me and him, we don't do good with trying to figure things out between each other. And for my safety, the kid's safety, and his safety, let's just try to find somebody else to communicate through.
All right, and these arrangements, did you make them by phone or text message?
By phone.
Okay, so you had spoken to Mr. Boston.
Mm-hmm.
Yes or no?
Yes. I'm sorry.
Okay. So you spoke to Mr. Boston and y'all agreed that your son would arrive at the party.
Yes.
What time was your son supposed to arrive at the party?
I can't remember exactly what time. I can't recall the time.
Okay, was it day? Was it evening?
It was it was probably about 3 o'clock. I'm gonna say about probably 2, 3 o'clock in the afternoon.
Okay. And how many people were you expecting at this party?
My sister, two of my sisters. My sister was gonna bring her stepkids, her 3 stepkids, and I had a friend that was coming with her daughter as well.
and
And had they arrived by the time that Mr. Boston was there?
No, when I arrived, I had texted everybody and told them I was there, and everybody was en route. We wasn't even there 5 minutes before I asked him, can we step outside and talk? And the girlfriend came outside too to talk too. And that's when the situation escalated.
All right, Mr. Lynch, continue.
so it's your testimony that your sisters talked to the police. You testified to that, correct?
No,
Oh, you didn't?
we didn't say anything about the sister talk to the police. The police just told
No,
you.
the testimony was that she talked to the police and a minor child talked to the police, her daughter.
You called 911 on at least 2 occasions. Isn't this correct? Didn't you call 911 on at least 2 occasions?
I'm not understanding what you're asking.
Did you call 911 to report your allegations that happened at the Chuck E. Cheese's?
Yes, I called 911.
And isn't it true that at the time you called 911, you were following Mr. Boston's car in your car?
No, sir.
So if the 911 recording does not have the 911 operator telling you not to follow Mr. Boston, that's your testimony?
I don't recall that, sir.
So
And if I did, it was because your court system has failed several times to protect me and my children from him assaulting me.
So
So
are you-
I wanted to make sure that they had a tag number or something to be able to serve Mr. Boston so that I can receive justice for a person not knowing how to control his anger and have self-control over himself. I can say whatever out my mouth. I can say whatever out my mouth.
All right.
If I don't put my hands on you, don't put your hands on me.
Ms. Benz, you're being non-responsive, which means that you're not answering the
I
question
just
that was
answered his
asked.
question.
Yeah,
So-
but then you went into this rant about people putting their hands on you. He asked you whether you followed the car or not. All right, Mr. Lynch, continue.
So at first you said you didn't follow the car, you didn't remember, but now you're explaining that you followed the car to try to get a tag number. Why did you make a false statement to the court just prior to the first question?
I said, I'm sorry, you know, this case happened in 2020. It's 2024, 4 years down the line. My knowledge of each detail of how the situation and what happened and took place there, sir, is fuzzy. Okay.
And let me ask you this. You mentioned controlling anger. Do you ever have any issues controlling your anger?
No, I haven't.
Okay. Excuse me. Isn't it true that you tried to attack Mr. Boston's girlfriend at this Chuck E. Cheese's?
Objection, relevance.
Okay. I'll move
You
on.
can pull the security camera and you can see everything.
Okay.
All right,
I don't have anything further at this time for Ms. Benz.
all right. Anything else from the state?
No, Your Honor.
Okay. All right.
May I? Excuse me.
Yes, sir.
Oh, I didn't mean to interrupt, Judge. I was just waiting for a chance to make some argument.
Okay. Does the state have any additional witnesses to present?
No, at this time, the state rests.
All right. Does the defense have witnesses or evidence to present on behalf of Mr. Boston?
No, Judge, we're not going to present any evidence today.
Okay. All right. Sorry. All right. All right. Let me hear argument.
Judge, may I proceed?
You may.
So first of all, and Ms. Hagler can correct me if I'm wrong, but I believe she indicated that the bond order was issued in 2022. This alleged incident happened in 2020. So he can't violate a bond that has not been set. So that's the first part of the argument. And I would, if I got that wrong, I would ask Ms. Hagler to correct.
I will make my argument when it's time for me to make my argument.
Sure.
Thank you.
Secondly, Judge, Mr. Boston has announced ready for trial on both the alleged incident, the criminal trespass, and on the battery case. And he strongly contests the allegations of Ms. Benz. I would have him testify today, but in order to do that, we would have to let our trial strategy go. We would also have to have him give up his right against self-incrimination. And we don't feel that that's necessary at point. However, Judge, from the testimony of Ms. Benz, it's pretty apparent that she voluntarily had contact with Mr. Boston at the Chuck E. Cheese's, number one. Number two, it's our position that, well, so it's our position he did not violate any bond by having contact with Ms. Benz because Ms. Benz came to where he was. We're going to contest and we're going to present evidence at the trial that that she found out about the Chuck E. Cheese on the day.
Okay, but if that's evidence you're not willing to present here, you can't argue it here.
Is that?
Sure, Judge. So I would also like to point out that Mr. Boston announced ready for the criminal trespass case which there's no allegation of any physical contact, not in the statement that was given to police. And now, inconsistent with that, Ms. Benz says that there have been multiple inconsistencies in her testimony, and Your Honor can use that to determine her credibility. Ultimately, a jury is the most appropriate fact finder to determine what happened in this case. I would like to point out that this motion to revoke bond was filed September 4th, 2020, the very same day when the state found out, or that when I announced to the state that we would not be entering pleas to either of these cases because we contest the allegations.
You mean 2024?
Sorry, 2024. So
Okay.
a full approximately 4 years after the alleged bond violation. Mr. Boston has been in court for every appearance. Mr. Boston is not running away from these charges. Mr. Boston looks forward to his day in court where a jury can evaluate the credibility of the claims with regard to the criminal trespass case and with regard to the allegation of battery family violence. Mr. Boston works full-time as an electrician. Mr. Boston does not have an extensive criminal history. So Judge, even if you were to find that there had been a bond violation, we only locking Mr. Boston up pre-trial is not the only action the court can take. So number one, we would argue that that has not been proven by a preponderance of the evidence. But number two, even if you believe that it has been, we would ask that you allow Mr. Boston to have his day in court. There would be no bond to violate if I had not gotten sick on the court date for the criminal trespass case. And I would ask you not to hold that against Mr. Boston either. He is aware of the bond conditions. He is not violating the bond conditions. He is willing to abide by any additional stipulations the court were to suggest in this case. But overall, Judge, based on what has been presented to this court, it has not been established that he violated his bond conditions. And again, even if it has, Judge, we would ask that you wait until he has his day in court. And then if he's convicted, then Your Honor obviously will have the ability to sentence him under the law.
Okay. All right, Ms. Haylor.
Thank you, Judge. The state would ask that you do revoke the defendant's bond until his trial. For clarity purposes, the order for bond that I did read out, yes, it was signed on May 13th of 2022, but on the bond order, it does have the criminal trespass damage to property case on there, warrant number 2020 CW 52107. And it also has the battery case that we're here today on as well. Again, the warrant number is 2020 CWC 1250. So both cases, the one that's currently on the calendar and the case that he's being revoked for, are on this one bond order. Based on the testimony that we heard, we did hear from Officer Green, who did testify that on November 9th of 2020, he did respond to the incident location regarding battery family violence. He did indicate that he did see visible injuries on the, he did indicate that he did see visible injuries on the defendant while at the Chuck E. Cheese. He did determine the defendant to be the primary aggressor. We also heard from Ms. Benz herself, who gave the same testimony that, the defendant did push her on that day while at Chuck E. Cheese and that she did sustain visible injuries. We also heard that there was a previous incident that again occurred on May 7th of 2020 in which the defendant did destroy her spiritual, her prayer room, her igun. He did put holes in the walls. And so, Your Honor, again, the order did say that he is to stay away from from the victim, Ms. Cassie Benz, and to not violate any laws. The reason why this motion to revoke was not filed early is because I wasn't here 1, 2, 3 years ago. I got here in July of this year. So that is why it is just now being brought to the court's attention now. And so for those reasons, testimony of Ms. Benz and testimony of Officer Green, we would ask that you revoke the defendant's bond until trial. Thank you.
Okay, so let me ask a clarifying question, Ms. Hagler. So you said that, so this is how I know magistrate to work, but it's been, I think I haven't been on magistrate court in 9 years, almost 10 years. Things may have changed. But generally, when a warrant is issued, if the person is arrested pursuant to that warrant, and a CW would mean that somebody, an officer came into the office, asked the magistrate to hear sworn testimony. The magistrate then types up the warrant, and at that point, the officer can proceed on that warrant. It is not one where the officer was present at the time the offense happened, which would have been a CAA, which would have been a warrantless, a WAA, or warrantless arrest affidavit. It would have been after some investigation or after going to the scene, the officer collects information, and then they go to a magistrate, ask that magistrate to produce a warrant, and then that warrant is then entered into the system and the person is wanted. My understanding from what you're telling me is that he was not initially arrested on the 2020 CW warrant. That warrant was still showing wanted when he was then subsequently arrested on the next case. And for both those cases, the bond condition was set to require that he have no contact with Ms. Benz. Is that correct?
Yes, no contact, and then not to violate any laws.
So when Mr. Lynch is testifying that for the 2020 CW, which would have been first in time, he did not have a bond condition until he was arrested on that and the subsequent event. So two events were committed. He wasn't arrested on the first one. When they arrested him on the second one, they processed both the CW and either another CW or a WAA. So one of them was in 2020, the other one was in, I think you said 2021 or 2020.
Both were in 2020. One occurred May 7th. The criminal trespass occurred May 7th of 2020. And then the battery family violence occurred November 29th of 2020.
But he wasn't arrested on any of them until 2022.
That based on this bond order, that's when it was signed.
Okay, so that's what that would have meant, that he was wanted for both of those things for almost 2 years. And when he was finally arrested on those two offenses, the court then had a first appearance hearing where he was given notice that he was not to have contact with a particular person, Ms. Benz, or go to a particular location possibly.
That's what appears from this warrant, from this order for bond. Sorry.
Okay, so, and this is where Ms. Benz is about to lose it, but Ms. Benz, let me explain to you what happened. So he had warrants that were out there, but he wasn't arrested. He wasn't arrested until later, and when he was arrested, then at that time, he was given notice of the bond conditions. I can't hold him responsible for bond conditions that weren't even in place at the time, or he didn't have knowledge of at the time. And so even though both of those events took place one after the other, had he been arrested on the first event and given a first appearance and been told that he had bond conditions, then I would be able to hold him accountable because he is knowledgeable that these bond conditions exist and you're not to have any other offenses and you're not to have contact with this particular person. Number one.
That case y'all won't allow us to talk about in the courtroom. They told him.
Ms. Benz, it doesn't matter whether you're allowed to talk about it or not. What I'm saying is the state of the bond conditions is until a bond condition is served upon the person and they're given notice that this is what you cannot do until that hearing is held, then they're not responsible for that. So he had two outstanding warrants. The first warrant, he was never arrested on until the second warrant happened. When he came to Chuck E. Cheese, then they were able to arrest him on that second warrant, the Chuck E. Cheese incident, and the first warrant, which was outstanding. And at that time, he was given bond conditions. Now, if he committed a crime after that, after the date that he was given the bond conditions, which was May 13th of 2022, if there is a crime that occurred after May 13th of 2022 that he was arrested for, then I could hold him on a bond revocation. But because he was not given bond conditions until the date in question, and that predated, those two offenses predated his bond conditions, I cannot hold him responsible for having violated the bond conditions. That's number one. And number two, even though there were no bond conditions in place at the time that you all agreed to meet at the Chuck E. Cheese, you admit that you agreed to have contact with him. What set it off was Mr.
I didn't admit
Boston,
to anything.
Miss Benz, let me finish. What you admitted that you agreed to have contact with Mr. Boston. What set it off was under your testimony is that he arrived with his girlfriend and her children, who were not expected to be there. And Miss Benz,
courtroom,
which he arrived with his girlfriend and her children, and they were not expected to be there. So at that point, that's what set off the encounter. But at that point, Mr. Benz was not under a bond condition from this court that this court can rely upon to hold him responsible. So with that being said and all laid out, Mr. Ben, I cannot revoke a bond condition, a bond for revocation where the condition was not in place at the time that the offense happened. So that's where that stands. And thank goodness for my knowledge as a magistrate court judge, because you got to walk this down slowly. Now, other things I want to say about this case. Ms. Benz, you are hot mad about what's going on in this situation, but you seem to be really, really
because you allow my abuser
Ms. Benz, you seem to be really, really focused on the girlfriend. And I understand that she's an irritation and an issue.
About the girlfriend, I'm focused on the safety of my son. They leave him home by himself. He's called me on his.
But I want to clarify certain things. One, I've never had any contact with DFACS about this case or about the minor child.
Last time in the court,
I don't know anything about the minor child in this case or his situation or his whereabouts. Three, if it is an issue where the minor child is endangered, then that is an issue for the police to handle under whatever offense is appropriate at the time. I have not directed Ms. Benz to do anything but to speak with the victim witness advocate in the Solicitor General's office and to seek possibly a temporary protective order. I have not directed the magistrate court to do anything. I've not directed any other body to do anything in this case because I don't have that ability. So I am not in charge of this, the safety, welfare, or have any knowledge about where this child is. I don't have any knowledge about what the legal status of the child is, whether Mr. Boston has any right to have the child or whether he has been granted a temporary guardianship or conservative, anything. I don't have any of that because that is not before me.
Okay.
If there is something going on with this child, then the child, that needs to be handled through the police or superior court, the superior court of the county where the child has resided. So if it's not handled by superior court, if it's not handled by the police, it is not something that is currently before me. I can't make Mr. Boston return a child because I don't have that power. And so just to be clear, Ms. Benz, I don't have the power to do what you're asking me to do. A superior court judge might, or the police might be able to arrest, but none of what has been said here and none of the cases in front of me involve a minor child. And so I'm putting that on the record. You can sue all you want to, you can rant, rave all you want to, but none of that involves this court. State court does not have jurisdiction over those matters. None of what has been alleged has anything to do with a minor child being involved. And therefore, I'm clarifying for the record that the allegations you made against this court can't be supported. And so if you want to pursue the custody of the child, then like I said, you need to go through Superior Court, or you need to go through the police and have them file a warrant for whatever they deem is appropriate, but it cannot come through me because I don't have that power. So everything that all the power that you've given me, I don't have. Okay, so with that being said, at this time, the motion to revoke is denied. The court has put on the record all of the information that it has regarding this case and the situation that exists. And at this time, Mr. Benz, I will remind you that you are currently under a bond condition that says that you're not to have any contact with Ms. Benz, that you're not to go around her, that you're not to have a third party contact her. And let me be clear, I hate cases where people bring in the girlfriend. The girlfriend did not have a child with Ms. Benz, and so she has no right to have any connection with Ms. Benz. She didn't lay down with Ms. Benz. She can't get up with Ms. Benz. And so when you bring the girlfriend in as a surrogate to participate in an argument with Ms. Benz or to talk to Ms. Benz in any way about Ms. Benz's child, that's inappropriate. You're the person who had a child with her. You need to have those conversations. Don't bring your other party around, especially when you know it's gonna be a problem. That's irresponsible. So let's start thinking about mature co-parenting as opposed to all of this high school stuff where I'm gonna bring my girlfriend and she gonna fight you and all that foolishness. It really is ignorant. So Ms. Benz, I've clarified my position in this. I've made my statement. I have reminded Mr. Boston that should you violate the conditions, you could be arrested until this case is resolved. You could also be charged with additional misdemeanors or felonies punishable by up to 10 years in prison, a $10,000 fine, or both per offense. And so at this time, the motion is denied, but the Solicitor General's office, per any information that they receive, could bring that motion to revoke back. And let me be very clear, it could be based on a third party contacting Ms. Benz, namely a girlfriend or some other family member or person acting on your behalf. So please tell them that they don't help you in any way by doing that. Okay, even if they're using an anonymous number, technology is such that things can be traced. Don't make them find it. All right, so that concludes this case. All righty.
Serve him without an address for you to even for me to even do the things you're telling me to do.
Ms. Benz, I can't ask him for his address. I can't compel him to give me that.
Forward to get my son to even do the legal things that you're telling me to do.
Ms.
How am I supposed to do this? What I'm saying?
Ms. Benz, let me just tell you something. Ms. Benz, if you will listen to me, let me tell you something. My mom she practices law in South Carolina, and this was a point she made to someone once. You have a child with somebody, you choose that person. If you got a child with somebody and you don't know their address, how do you think I'm gonna figure it out? I don't know him. I don't know where he's lived. I don't know his people. I don't know who he is. You have way more information than I do. I can't compel him to give me his information, and I didn't have a child with him. So that's what I say. When we're having kids with folk that we barely know. Folk are just having kids with people that they barely know. They're having kids with people that they wouldn't even marry, but they're having kids with them. And then you expect the courts to enforce a relationship that you don't even have.
Judge,
So I'm not going to take that abuse because she failed to have a child with the right person or to get the right information. I'm not doing that. Y'all need to be more careful about who you procreate with. I'm serious about that. Children being brought into this world in the midst of foolishness, and the foolishness just continues. And the only people who suffer are the kids. So Ms. Benz can have whatever tantrum she wishes to have, but I have made my ruling and I have put it on the record. All right. So next, 1 o'clock calendar.
Your Honor, before you move to the 1 o'clock, I do have an announcement for the motion to seal for Washington for his 2 cases, whenever you're ready.
Okay, I'm ready.